One wrong move with your newly purchased suppressor in 2026, and you're looking at felony charges, even though you thought the new rules made it easier. In the next 30 days, 10 ATF rule changes will completely reshape how you own, carry, and transfer firearms. One mistake could cost you $250,000 in fines and 10 years in federal prison. Today, I'm breaking down 10 critical ATF rule changes coming in 2026 that could land you in federal court if you don't understand them. By the end of this video, you'll know exactly how to stay compliant under the new regulations and avoid the traps that are already catching unprepared gun owners. Here's why this matters right now. The ATF is rolling out these changes starting January 1st, and early enforcement patterns show they're targeting confusion. Gun owners who think no tax stamp means no rules are getting hit with possession charges. Homemade firearm builders are facing serialization violations they never saw coming, and the consequences are devastating. We're talking felony records, loss of gun rights forever, and 5-figure legal bills just to fight the charges. This is happening right now to gun owners just like you. Let's make sure you're not next. Number 1. The NFA tax stamp elimination that everyone thinks means anything goes. Starting January 1st, 2026, the $200 NFA tax stamp fee is gone for suppressors, short-barreled rifles, short-barreled shotguns, and AOWs. Sounds great, right? Here's the problem. Gun owners are hearing no tax and thinking no regulation, and that's landing them in federal custody. Picture this scenario. You walk into your dealer, buy a suppressor, and because there's no $200 fee anymore, you assume you can walk out with it that same day. You take it to the range that weekend. Monday morning, ATF agents are at your door with a warrant. Why? Because elimination of the tax does not eliminate registration, background checks, or the approval process. Under 26 U.S.C. Section 5861, possessing an unregistered NFA item is a federal felony. That means up to 10 years in prison and a $250,000 fine. The tax is gone, but the waiting period isn't. The paperwork isn't. The approval requirement isn't. Just this year, we've already seen cases in Texas and Florida where gun owners thought the no tax meant immediate possession. Those cases are now federal prosecutions. Career-ending, life-ruining consequences for misunderstanding one rule change. Here's exactly how to stay legal. First, when you purchase any NFA item in 2026, you still submit your Form 1 or Form 4 through eForms. Second, you still wait for approval, which could be days or months depending on volume. Third, you do not take possession until you have that approval confirmation in hand. Print it, save it, keep it with the item. The rush is already starting. Dealers are reporting suppressor sales up 300% in some states. That means wait times could spike from weeks to months as the system gets flooded. Plan ahead. Don't assume no tax means instant access. If you've been waiting to buy a suppressor or SBR, 2026 is your year, but only if you follow every single step of the approval process. Skip one step and you're facing federal charges. But here's something even more dangerous that's catching gun owners off guard. Number 2. eForms processing changes that are creating a false sense of security. The ATF is promising faster turnaround times in 2026. Form 1 approvals could come back in days. Form 4 transfers might take weeks instead of months. That sounds incredible, until you're the one who assumed fast meant instant, and now you're holding an illegal item. Here's where this becomes dangerous. You file your Form 1 to build an SBR. 3 days later, you get an email notification. You think it's your approval. You start your build that weekend. Turns out, that email was just a submission confirmation, not approval. You've now manufactured an unregistered SBR. That's a federal felony under the National Firearms Act. The consequence is brutal. Each violation carries up to 10 years in prison and $250,000 in fines. And here's the worst part. The ATF doesn't care that you thought you were approved. Intent doesn't matter under NFA violations. Possession of an unregistered item is a strict liability crime. We're already seeing this happen in early 2026 cases. A gun owner in Arizona filed his Form 1, saw a 3-day turnaround notification, and started his build. ATF traced the serial number during a routine dealer audit. That gun owner is now facing federal prosecution because he didn't wait for the actual approval document. Here's your action plan to avoid this trap. First, file electronically through the ATF eForms system whenever possible. That's non-negotiable now. Second, do not start any build. Take possession of any item or modify anything until you have received and verified your actual approval document with a control number. Third, save that approval document in 3 places: digital copy on your phone, printed copy with the firearm, and a backup in your safe. And here's the critical part. Do not trust processing estimates. Right now, the ATF is saying days to weeks, but volume spikes could push that to months. A dealer in Georgia just reported a Form 4 transfer that took 73 days in January 2026, even though the estimate was 14 days. Plan for delays. Don't buy gear assuming instant approvals. If you're planning any NFA purchase or build in 2026, add 60 days of buffer time to whatever the ATF promises. Better to wait an extra month than spend the next decade in federal prison. Now here's where things get even more complicated for home builders. Number 3. Ghost gun and frame receiver enforcement that's hitting home builders harder than ever. The 2022 ghost gun rule is now fully backed by federal courts, and in 2026, the ATF is treating unfinished frames and receivers like complete firearms if they're sold as kits that can be readily converted. This is where thousands of home builders are about to walk straight into federal charges. Here's the scenario. You buy what's marketed as an 80% lower online. It comes with a jig, drill bits, and instructions. You think you're good because it's not a firearm yet. You complete the build in your garage. You never serialize it because you're keeping it for personal use. 6 months later, your house gets broken into, and that gun is stolen. Police recover it at a crime scene. Now you're facing federal charges for manufacturing an unmarked firearm. Under the new enforcement guidelines, that 80% kit is being treated as a firearm at the point of sale if it comes with the parts and instructions to complete it. That means the seller should have run a background check. That means you should have a serial number. That means you're now in violation of 18 U.S.C. Section 922K. Possession of a firearm with an altered or removed serial number. The penalty? Up to 5 years in federal prison and a $250,000 fine. And that's just for possession. If you sell or transfer that homemade gun without proper serialization, you're looking at additional charges for unlicensed dealing. We saw this exact scenario play out in Pennsylvania last year. A gun owner built 3 AR-15s from 80% kits for personal use. Never serialized them. One was stolen. ATF traced it back to him. He's now serving 36 months in federal prison. Here's exactly how to stay legal if you build at home. First, check whether your kit is now classified as a firearm under the new definition. If it comes with everything you need to complete it in one package, assume it requires serialization and a background check. Second, if you're building from a true unfinished receiver, you must serialize it before it enters commerce, meaning before you sell, transfer, or even gift it. Third, use the ATF's marking guidelines. Engrave the serial number, your name or maker's mark, city, and state on the receiver. Depth must be at least 0.003 inches. Size must be at least 1/16 inch. The safe move? If you're building for personal use and never plan to transfer it, serialize it anyway. If your home is burglarized, if you're in a defensive shooting, if that gun ever enters law enforcement hands for any reason, having no serial number turns you from victim to suspect instantly. Do not assume that 80% automatically means no rules anymore. The rules changed, and enforcement is aggressive. Protect yourself with proper marking from day one. But there's one rule change that's actually giving gun owners relief, if you understand it correctly. Number 4, the pistol brace classification reset. That sounds like good news, but is still sending gun owners to federal court. The ATF's 2023 pistol brace rule has been walked back. In 2026, braces are being treated more like they originally were. The brace itself doesn't automatically turn your pistol into an SBR. Gun owners are celebrating, but here's what they're missing. The underlying NFA definition of an SBR didn't change, and that's where the arrests are happening. Here's the dangerous scenario. You have an AR pistol with a 10.5-inch barrel and a stabilizing brace. You hear the rule changed. You think you're in the clear, but your overall length is under 26 inches. You've added a vertical foregrip, and you've been shouldering it at the range. An ATF agent observes you. You're now being charged with possessing an unregistered SBR. Why? Because even though the brace rule was walked back, if your configuration meets the NFA definition of a short-barreled rifle based on barrel length, overall length, and intended use, you can still be in SBR territory. The brace isn't the deciding factor. The weapon's configuration is. Under 26 U.S.C. Section 5845A.3, an SBR is a rifle with a barrel length under 16 inches or overall length under 26 inches. If you shoulder a braced pistol, you're demonstrating intent to use it as a rifle. If you add a vertical foregrip to a pistol, you've created an AOW. These are NFA items requiring registration. The consequences are severe: 10 years in federal prison, $250,000 in fines, and permanent loss of gun rights. Just last month, a gun owner in Nevada was charged with SBR possession after posting range videos on social media, showing him shouldering his braced AR pistol. The ATF used his own content as evidence of intent. Here's how to stay legal with pistol braces in 2026. First, measure your barrel length precisely. If it's under 16 inches, your weapon is not a rifle. It's a pistol or an NFA item. Keep it in pistol configuration. Second, keep your overall length over 26 inches if possible. Third, do not add vertical foregrips to pistols. Use angled foregrips instead. Fourth, if you're shouldering your brace regularly, seriously consider filing a Form 1 and registering it as an SBR properly. The safest approach? If you're unsure whether your setup is compliant, take it to a qualified gunsmith or attorney for configuration review. A $200 consultation is infinitely cheaper than a $50,000 legal defense. Measure twice, register once, or don't build it at all. The brace rule may have changed, but the NFA definition didn't. Don't let relief turn into complacency. Now let's talk about something that affects every gun buyer in America. Number 5, dealer enforcement policy changes that sound like good news, but create hidden risks for you as a buyer. The ATF is backing off the most aggressive one mistake and you're done enforcement approach for FFLs. Dealers are breathing easier. But here's what gun owners need to understand. Your dealer's paperwork mistakes can still become your legal nightmare. Here's the scenario that's playing out right now. You buy a handgun from a local FFL. The dealer makes an error on your Form 4473. Maybe they checked the wrong box for your state of residence, or they failed to properly record a corrected answer. 6 months later, ATF audits that dealer. They find the error. Now you're getting a letter asking you to prove lawful possession, even though you did nothing wrong. Under 18 U.S.C. Section 922(m), even minor paperwork errors can trigger investigations. And while the dealer might face reduced consequences under the new policy, you can still face questions about your possession. The burden shifts to you to prove everything was legitimate. The consequences can be devastating. Even if you're ultimately cleared, you're looking at legal fees to respond to ATF inquiries, potential temporary seizure of the firearm during investigation, and the stress of being under federal scrutiny. In extreme cases where the error is significant, you could face actual charges for unlawful possession. We've seen this in Michigan recently. A dealer miscoded a buyer's state of residence on the 4473. ATF flagged it as a potential straw purchase. The buyer, completely innocent, spent $8,000 in legal fees and 3 months of investigation before being cleared. Here's your protection plan. First, choose reputable FFLs with clean compliance records. Ask around. Check online reviews. A dealer who cuts corners on paperwork is a dealer who could drag you into their mess. Second, review your Form 4473 carefully before you sign it. Check every box, every date, every answer. If something looks wrong, speak up immediately. Third, keep your own records. Take a photo of your completed 4473 with your phone before you leave. Save your receipt. Document the serial number and make /model. Fourth, and this is critical, if you ever receive any communication from ATF about a past purchase, do not ignore it and do not respond without an attorney. Even clarification requests can be evidence gathering. Hire a firearms attorney immediately. The new enforcement policy does not mean dealers are safe to be sloppy, and it definitely doesn't mean their mistakes won't affect you. Protect yourself by being your own compliance officer on every single purchase. We're halfway through these changes now, and if you're feeling overwhelmed, you're not alone. That's exactly why I break down complex gun laws every week on Guns Law Guide. Hit that subscribe button so you don't miss the detailed breakdowns coming for each of these rules. And stick with me, because Rule 9 is the most controversial change and could affect millions of gun owners who build at home. But first, let's talk about the form that every gun buyer fills out. Number 6. The updated Form 4473 and background check questions that are catching legal gun owners in federal traps. The ATF is updating Form 4473 again in 2026 to reflect newer federal definitions. Things like prohibited persons, marijuana use under federal law, and domestic violence convictions. This sounds like routine administrative updates, but here's the deadly truth. One wrong answer on this form is a federal felony. even if you didn't intend to lie. Here's the nightmare scenario that's happening right now. You live in a state where marijuana is legal. You used it 3 weeks ago. You walk into a gun store to buy a handgun. You fill out Form 4473. Question 21.g asks, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? You think, it's legal in my state, so I'm not an unlawful user. You check no. You buy the gun. You just committed a federal felony. Under 18 U.S.C. Section 922(g)(3) and Section 922(a)(6), lying on Form 4473 carries up to 10 years in federal prison and a $250,000 fine. And here's the brutal reality. What your state says is legal and what the federal form requires are not the same thing. Marijuana is still illegal under federal law, regardless of state legalization. We're seeing prosecutions exactly like this. In Colorado, a gun owner was charged with lying on Form 4473 after an ATF trace revealed his marijuana use. He argued state legalization as a defense. The federal court rejected it. He's now serving 18 months in federal prison. But it gets worse. The 2026 update also clarifies domestic violence questions. If you have any domestic violence conviction, even a misdemeanor from 15 years ago, you're a prohibited person under federal law. If you check no to question 21.I without disclosing that conviction, you've just committed perjury on a federal form. Here's exactly how to protect yourself. First, read every single question on Form 4473 like your freedom depends on it, because it does. Read it out loud if you have to. Second, if you have any uncertainty about how to answer a question, stop. Do not guess. Do not assume. Ask the dealer for clarification. And if they can't give you a clear answer, consult a firearms attorney before proceeding. Third, understand that legal in my state does not mean legal under federal law. Federal law governs Form 4473, period. Fourth, if you've used marijuana recently, even in a legal state, wait at least 12 months before purchasing a firearm. Federal prosecutors have used recent use as proof of being an unlawful user. Fifth, if you have any old convictions in your record, domestic violence, misdemeanor assault, anything, pull your full criminal history and review it with an attorney before you attempt to purchase a firearm. A single wrong answer can be a federal felony. What the form asks and what you think it's asking are not always the same thing. Read every line, every question, every time, even if you've bought 20 guns before. This is where complacency destroys lives. And if you think answering the form correctly is enough, wait until you hear what happens when you buy multiple guns. Number 7. Multiple sale and trafficking focus that's putting law-abiding gun owners under federal investigation. The ATF is increasing scrutiny on multiple handgun sales and patterns they believe look like trafficking. Your dealer has always been required to report when you buy 2 or more handguns within 5 consecutive business days. But in 2026, enforcement priority is higher, and the triggers for investigation are broader. Here's the scenario that's catching innocent gun owners. You buy 2 Glock 19s on Monday because you got a great deal and want one for your wife. Wednesday, you buy a third handgun, a SIG P365 for concealed carry. Friday, your dealer calls and says ATF wants to interview you about your purchases. You think, I'm just buying guns legally, what's the problem? The problem is that your purchase pattern looks like trafficking to ATF. Under 18 U.S.C. Section 922(a)(1), dealing in firearms without a license is a federal felony. And here's what triggers ATF's suspicion. Multiple handgun purchases in a short time window, especially if the guns are popular models used in crime, purchased with cash, or if you're unable to clearly articulate why you need multiple firearms. The consequence of being investigated, even if you're cleared, includes interrogation by federal agents, requests to see all firearms you own, potential surveillance of future purchases, and your name flagged in ATF databases. If the investigation concludes you are trafficking, you're looking at up to 5 years in federal prison per count. We saw this happen in Virginia last year. A gun owner bought 4 Glock 17s over 6 days, all for legitimate reasons, including gifts for his sons. ATF investigated him for 6 months, seized 2 of the firearms, pending investigation, and ultimately dropped charges. But he spent $12,000 in legal fees and lost use of his property for half a year. Here's how to protect yourself from false trafficking flags. First, if you're planning to buy multiple firearms in a short time window, document your reasons in advance. Write it down. Keep receipts showing you're buying cases, holsters, and accessories for each gun. If questioned, you want clear evidence of personal use. Second, avoid buying multiple identical guns unless you can articulate why. They were on sale is not a compelling defense in a trafficking investigation. Third, never purchase firearms on behalf of someone else. That's a straw purchase, which is a separate federal crime under 18 U.S.C. Section 922(a)(6). Even if your wife gives you money to buy her gun, you must be the actual buyer. She needs to be present and fill out her own 4473. Fourth, if you receive any contact from ATF about your purchase patterns, hire an attorney immediately before responding. The 2026 enforcement focus means ATF is dedicating more agents to investigating these patterns. Multiple purchase reports are getting reviewed faster and flagged more aggressively. If you're buying multiple firearms legitimately, make sure you can clearly explain why, and make sure every transfer is clean and documented. Don't let a good deal at the gun store turn into a federal investigation. Plan your purchases, document your intent, and know what triggers suspicion. Now here's a change that's affecting dealers, but has major implications for your privacy. Number 8. Digital record keeping for FFLs that's making your purchase history more accessible than ever before. More FFLs are being pushed toward digital record keeping and longer retention of Form 4473 records. The ATF says this is for efficiency and faster trace requests. But here's what gun owners need to understand. Your purchase history is now being stored in organized, searchable digital formats that can be accessed far more easily than the old paper-only systems. Here's why this matters. You buy a handgun in 2026. Your dealer stores your Form 4473 digitally in their bound book system. 5 years later, that gun is stolen and recovered at a crime scene. ATF issues a trace request. In the old system, this could take weeks of manually searching paper records. In the new digital system, ATF can get your information in hours, including every other gun you've purchased from that dealer. Under 27 CFR Section 478.129, FFLs must maintain records of all firearms transactions and make them available to ATF upon request. The new digital systems make compliance easier for dealers, but they also make it easier for ATF to build complete purchase profiles on gun owners. The concern here isn't about legality. If you're buying legally, you have nothing to hide. The concern is about scope and accuracy. Digital records can be searched, cross-referenced, and analyzed in ways paper records never could. And if there's an error in those digital records, wrong serial number, wrong date, wrong buyer information, it's now replicated across multiple systems. We're already seeing the impact. In Texas, a gun owner was flagged in a database error that showed him as a prohibited person due to a clerical mistake by an FFL. That error propagated through ATF's digital trace system. He was denied on 3 subsequent background checks before the error was corrected, a process that took 14 months and required an attorney. Here's how to protect yourself in the digital record era. First, secure your firearms properly. Install a quality safe, use trigger locks, and document your serial numbers. If a gun is stolen, report it to police immediately. The faster it's reported, the less likely you'll be connected to its misuse. Second, keep your own purchase records separate from dealer records. Photograph your 4473s, save your receipts, and document serial numbers independently. Third, and this is critical, if you ever have to deal with a wrongful denial, prohibition, or database error, hire an attorney who specializes in firearms law. Do not try to fix these errors yourself by calling ATF directly. You need representation. Fourth, consider the long-term implications of your purchases. Everything you buy is now part of a searchable digital record that could be accessed during traces, audits, or investigations for decades. If that makes you uncomfortable, that's even more reason to secure your firearms properly and report any thefts immediately. The best defense against being implicated in a crime involving your gun is having a documented, reported theft on record. Digital records are here to stay. Adapt your security and documentation practices accordingly. Now we get to the most controversial change, one that's affecting home builders across the country. Number 9. Homemade firearm marking requirements that are turning personal builds into federal prosecutions. Homemade firearms that enter commerce, meaning you sell, transfer, or even sometimes gift them, can trigger new marking and serialization rules under ATF guidance. This is where millions of home builders are about to cross a line they don't even know exists. Here's the scenario that's becoming more common. You build an AR-15 from an 80% lower for personal use. You put hundreds of dollars and hours of work into it. 2 years later, your financial situation changes and you need to sell it. You post it on a gun forum. You find a buyer. You meet at a parking lot. Complete the transfer legally under your state's laws. You think everything's fine. 3 months later, ATF agents are at your door with a warrant. Why? Because the moment that homemade firearm entered commerce, when you sold it, it triggered federal marking and serialization requirements under the 2022 rule. That unmarked gun you sold is now considered an unidentified firearm under 18 U.S.C. Section 922K. The buyer reported the lack of serial number to ATF. Now you're facing federal charges for transferring an unmarked firearm. The penalty is severe, up to 5 years in federal prison and $250,000 in fines. And here's the critical distinction. A personal build that never leaves your control is treated differently than one you sell, transfer, or gift. Once it enters commerce, ATF expects it to look like a commercially made gun on paper, with proper serialization, marking, and documentation. We've seen this exact prosecution in Oklahoma. A gun owner built 3 AR-15s over several years, all for personal use. Economic hardship hit, and he sold 2 of them through private sales. Neither was serialized. The buyers reported the lack of markings. That gun owner is now serving 42 months in federal prison for 2 counts of transferring unmarked firearms. Here's exactly what you need to do if you build at home. First, understand the critical line: personal use versus commerce. If a gun never leaves your physical possession, you build it, you keep it, you never sell or transfer it. Serialization is recommended, but not strictly required under current enforcement. But the moment you intend to sell, transfer, or gift it, serialization becomes mandatory before that transaction. Second, if you're going to serialize, do it properly. Use the ATF marking guidelines. Your serial number must be unique. It must include your name or maker's mark, city, and state. It must be engraved on the receiver at a depth of at least 0.003 inches and a size of at least 1/16 inch. Use a professional engraving service if you're not confident doing it yourself. Third, document your builds. Keep records of when you built it, what parts you used, and whether you ever transferred it. If you're ever questioned, you want to be able to prove the timeline and intent. Fourth, if you've built guns in the past and you're thinking about selling them now, serialize them first. Do not transfer unmarked homemade firearms in 2026. The enforcement priority is too high. And here's the hardest truth. If you build firearms intending to sell them, even occasionally, you may need a federal firearms license. Building guns for profit, even small profit, can trigger dealing requirements under 18 U.S.C. Section 922A. 1 build for personal use is fine. 10 builds that you sell over 2 years? That's looking like dealing. If you build, know exactly when you cross that line. The difference between a personal project and a federal felony is often just documentation and intent. One more critical change to cover. This one affects your privacy and how law enforcement tracks gun owners. Number 10. Information sharing with local law enforcement that's putting your purchase history in more hands than ever before. In 2026, the ATF is expanding information sharing with state and local agencies on certain flagged purchases, prohibited possessors, and trafficking leads. This means data that used to stay at the federal level is now flowing down to state police, county sheriffs, and city police departments. Here's the scenario law-abiding gun owners need to worry about. You buy a rifle in 2026. That purchase is recorded in the dealer's digital system and reported to ATF through NICS. 3 months later, someone with a similar name and birth date is flagged as a prohibited person in a neighboring state. Your record gets swept up in a database query. Now your local sheriff's department has your name on a list of persons of interest for firearms violations, even though you did nothing wrong. Under 18 U.S.C. Section 922G, being a prohibited person in possession of a firearm is a federal crime. The new information sharing protocols are designed to help local agencies identify and investigate these cases faster. But here's the problem. Database errors, mistaken identity, and bureaucratic mistakes can put innocent gun owners on these shared lists. The consequence of being wrongly flagged includes traffic stops where officers treat you as armed and dangerous, delays, or denials on future background checks until the error is cleared, and potential home visits from local law enforcement investigating prohibited person in possession reports. Even after you're cleared, the stigma and stress of being investigated can follow you. We're already seeing this happen in Illinois. A gun owner with a common name was flagged in an information-sharing query as a prohibited person due to a clerical error in another county. His home was visited by sheriff's deputies at 6 a.m. with a search warrant for his firearms. After 4 hours of searching and confiscation of 3 guns, the error was discovered. He got his guns back 6 months later, after spending $6,000 on legal fees to challenge the seizure. Here's how to protect yourself in the information-sharing era. First, keep your own records immaculate. Document every legal purchase with receipts, serial numbers, and dates. If you're ever questioned, you need to be able to prove immediately that all your firearms were lawfully acquired. Second, check your own criminal record periodically. Pull a full FBI background check on yourself every few years. If there are errors, old convictions that should be expunged, mistaken identity, clerical mistakes, get them fixed now before they propagate through shared databases. Third, if you have a common name, consider adding middle initials, full dates of birth, and address information to all firearms transactions to reduce mistaken identity risks. Fourth, if there's a mistake in your record, clean it up faster than ever before. Wrongful prohibitions or old records that should be sealed can now cause headaches at the state and local level, not just federal. Fifth, and this is critical, if local law enforcement ever contacts you about your firearms based on a shared ATF list, do not consent to searches, do not answer questions without an attorney present, and do not voluntarily surrender firearms without seeing a warrant. Even if you have nothing to hide, mistakes in these systems are common, and your cooperation can be used against you if the situation escalates. For the law-abiding gun owner, this mostly means, if there's a mistake in your record, it can cause more headaches, more quickly, and with more agencies involved. The safety net is getting wider, but so is the potential for errors. Protect your records, verify your background, and know your rights when law enforcement comes knocking. Let's recap the 10 ATF rule changes in 2026 that could land you in federal court. Number 1. NFA tax stamp elimination. No tax doesn't mean no rules. You still need approval before possession. Number 2. E-forms processing changes. Faster doesn't mean instant. Wait for actual approval documents. Number 3. Ghost gun enforcement. 80% kits now require serialization. Home builds must be marked before sale. Number 4. Pistol brace reset. The brace itself isn't the issue. Overall configuration still determines SBR status. Number 5. Dealer enforcement policy changes. Reduced penalties for dealers don't protect you from their paperwork mistakes. Number 6. Updated Form 4473. One wrong answer is a federal felony. Read every question like your freedom depends on it. Number 7. Multiple sale reporting. Buying several guns quickly triggers trafficking investigations. Document your intent. Number 8. Digital record keeping. Your purchase history is now searchable. Secure your guns and report thefts immediately. Number 9. Homemade firearm marking. Personal builds must be serialized before you sell or transfer them. Number 10. Information sharing with local law enforcement. Database errors can put you on law enforcement lists across multiple agencies. Any one of these mistakes could cost you thousands in legal fees, your freedom, or your right to own guns forever. These aren't hypothetical scenarios. These are real prosecutions happening right now to gun owners who thought they were following the rules. I know this was a lot to absorb. The goal here isn't to scare you. It's to keep you out of prison and keep your rights intact. Gun laws are complex, enforcement is aggressive, and 2026 is bringing changes that most gun owners have no idea are coming. Don't let confusion about gun laws put you at risk. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. I break down complex gun laws every week with state-specific guides, step-by-step compliance checklists, and real case analysis. Hit that subscribe button and turn on notifications. If this video helped you understand what's coming in 2026, do me a favor, hit that like button so this reaches more gun owners who need to see it. These changes are flying under the radar, and most people won't know about them until it's too late. Drop a comment with your state and which of these 10 rules worries you the most. I read every comment, and I'll prioritize detailed breakdowns and state-specific videos based on what you tell me. Next video, I'm covering the 7 concealed carry mistakes that are getting people arrested right now, including one that most CCW instructors don't even teach. You won't want to miss it. Stay safe, stay legal, and I'll see you in the next one.